Hi, my name is Carrie Faniff, and I'm the Vice President of Loss Prevention at Texas Lawyers Insurance Exchange. Today, we're going to do a Fast 15 on Texas Disciplinary Rule of Professional Conduct 2.02, dealing with evaluation for use by third persons. Now, we're just going to do 15 minutes, so this is very high level, and we're not going to get super into the weeds, but I'm going to try and hit the high notes and let you know what Rule 2.02 is all about. Just a little bit about me before we get started. I've been on staff here at TLIE since July of 2024. Before that, I was in private practice for 26 years. And during that time, I represented lawyers in legal malpractice cases filed against them and in grievances before the State Bar of Texas. So that's how I'm able to talk to you about these things that we're going to discuss here today. So let's jump right in with Rule 202. And it's a very short rule. There's not a lot of meat to it. It says a lawyer shall not undertake an evaluation of a matter affecting a client for the use of someone other than the client unless the lawyer reasonably believes that making the evaluation is compatible with the other aspects of the lawyer's relationship with the client and the client consults after consultation. So what in the heck does that mean? Well, we're going to talk about it. First, we're going to look at comment 1 to Rule 202, and it says an evaluation may be performed at the client's direction, but for the primary purpose of establishing information for the benefit of third parties. So the client is asking you to do something, but it's really to benefit a third party who is not your client. And then the comment gives some examples of when that might occur. The examples they talk about are, or the comment talks about, is an opinion concerning the title of property that is at the request of a vendor for a prospective purchaser or at the request of a borrower for a prospective lender. A opinion about the legality of securities registered for sale under the securities law, which would be required by a government entity, or an evaluation required by a third person, such as the purchaser of a business. Some other examples might be warranties that are prepared by lawyers, title certificates, offering statements, offering memorandums, warranty deeds, deeds of trust. Those things might be situations where the lawyer is giving an opinion for someone else to rely upon. The most important comment of this rule, in my opinion, is comment 5. And there's two parts that we're going to talk about here. We're going to start with the first part. And it points out that when a lawyer is giving information for a third party to use and rely upon, that's a departure from the attorney-client relationship. That is not normally what we do. We are normally only giving information to our client to rely upon. So because it is a departure from that relationship, the normal client-lawyer relationship, the lawyer really has to be satisfied in their professional judgment that doing that is compatible with other functions undertaken on behalf of the client. Okay, what does that mean? Well, the example given in the comment is that if the lawyer is acting as an advocate for a client or defending a client who's being accused of fraud, it would not be compatible with that responsibility for the lawyer to then perform an evaluation for others concerning the same fraud. Really, it means you've got to make sure and confirm there's no conflict of interest between your client that you're still representing and giving this opinion or this information to a third party that they're going to rely upon. So our general conflict of interest rule, the Texas Disciplinary Rule of Professional Conduct, general conflict of interest rule is Rule 1.06. And so you would need to look at, just very briefly, first, is it a substantially related matter in which that person's interest, the third person's interest, are materially and directly adverse to the interest of your client? That would be a conflict if those things were true. Or does the representation of or the opinion you're going to give to this person reasonably appear to be adversely limited by the lawyer's responsibilities to the client? And so that would be the second situation where there could be a conflict. The representation reasonably appears to be adversely limited by the lawyer's responsibilities to the client or to a third party or to the lawyer. If those things are true, then you really cannot be giving information or opinions to a third party for them to rely on under Rule 2.02. So the second part of comment 5 that I really want to call out to you is that assuming there's no conflict, there's no impediment to the lawyer giving this information for a third party to rely upon, the lawyer still has to advise the client of any implications regarding that fact. The lawyer is going to be giving information to a third party. So it says the lawyer should advise the client on the implications of the evaluation, particularly the lawyer's responsibilities to the third persons and the duty to disseminate any findings. So again, what does that mean? Well, in Texas now, under the disciplinary rules, we have a defined term for informed consent. And although this rule does not say that you have to get informed consent from your client, it does say that the client has to consent. So the best practice would be to get informed consent from the client if you are going to give information to a third party for use under Rule 2.02. What does that mean? That informed consent means it is an agreement by your client to a proposed course of conduct after you have communicated adequate information and explanation to them of the material risks and the reasonably available alternatives. The comment to informed consent says that means you've got to disclose the facts and circumstances. You have to explain the material advantages and disadvantages to the proposed course of conduct, and you have to discuss their options and alternatives. So you need to do all those things before you could move forward, under Rule 2.02. So this next slide I'm going to talk about is where you have an intersection between the disciplinary rules and legal liability. Because when you give an evaluation to third parties, as is discussed under 202, you can expose yourself to liability even if you follow 2.02. So generally in Texas, an attorney owes no duty of care to a third party absent privity. But the Texas Supreme Court told us in 1999 in the McCamish v. Appling Interest case that there is an independent duty to a non-client based on a lawyer's manifest awareness that the non-client is relying on a representation by the attorney and the attorney's intention that the non-client rely. And the reason I'm talking about this case is because this case actually discussed Rule 202 in it. And it is the only case that I could find where there was any kind of discussion of Rule 202 and how it intersected with this potential lawyer liability for making a representation to a third party. So just real briefly, the facts of this case are relevant. The facts were that there was a company called Boca Chica that had sued its lender, VSA. They were worried, though, during the lawsuit that VSA would be declared insolvent by the Federal Savings and Loan Insurance Corporation. So they settled. But Boca Chica's parent company would not agree to the settlement unless VSA's lawyers represented in writing as part of the settlement that the settlement would be enforceable even if the FSLIC, the Federal Savings and Loan Insurance Corporation, stepped in. The lawyers, in fact, made those representations and signed the agreement. Unfortunately, the board of directors of VSA made a misstep. They did go into supervision with the Texas Savings and Loan Commission, who took over the power to settle all lawsuits. And VSA was put under the control of the Texas Savings and Loan Commission. As a result of that, it said no action taken by the board of directors would be valid or binding unless it was approved by the commissioner. Well, even though the board of directors had approved or did approve the settlement with Boca Chica, they didn't get it approved by the commissioner. The commissioner never ratified that settlement. It was later determined not to be binding. And so Appling then sued the law firm who made the representations. And the crux of the lawsuit was based on Section 552 of the Restatement of Torts. That's important. So the law firm, the McCamish law firm, argued there was no privity, and so they could not be sued for this negligence arising out of the representations. And the Texas Supreme Court was answering the question in this case of whether a non-client, here Appling, could bring a negligent misrepresentation cause of action as defined by the restatement, Section 552. So I have the restatement second of torts, section 552 here up on the screen. It has all the elements. I'm not going to read them to you in the interest of time, but you can see them here. But basically, this was adopted by the Texas Supreme Court, and they said in the McCamish case that this cause of action, as set forth in section 552, could be against a lawyer, even if there was no privity. Where they talked about Rule 202 was in response to the argument by McCamish. That said, McCamish was arguing that if you make us liable under 552, you're putting that duty on an attorney to a non-client, then you're hampering our ability to zealously represent our clients. And McCamish claimed that it would create a conflict of duties between the client and the non-client if they were liable under Section 552, and it would threaten the attorney-client privilege. So this is where the Texas Supreme Court specifically addressed Rule 2.02, and what they said was, that lacks merit. And the reason it lacks merit is because, typically, a negligent misrepresentation case involves one party to a transaction receiving and relying on an evaluation, such as an opinion letter prepared by another party's attorney. And then it said, under the disciplinary rules, an attorney cannot give an evaluation to a third party unless, and the things that we already discussed, they reasonably believe that the evaluation was compatible with the other aspects of the attorney-client relationship, and the client consented after consultation. And then once the lawyer was satisfied there was no conflict of interest, then they could move forward, but had to advise the client of the implications. So we talked about those elements at the beginning, and the Supreme Court reiterated those. And then they said, because of Rule 202, that is a safeguard against a lawyer's exposure to conflicting duties. So remember, McCamish said, you're putting us in a conflict situation if you make us have a duty to this third party. The Supreme Court said, no, Rule 202 is guarding against that. It is ensuring that the client is the one that's making the ultimate decision of whether to provide the evaluation, because remember, the client has to give consent. And then the Supreme Court said, moreover, under Rule 202, a lawyer should not allow a client to make this decision without advising the client about the potential impact of the lawyer giving this kind of evaluation and the impact it may have on the scope of the attorney-client privilege. So the Supreme Court here was using Rule 202 to say there are safeguards in place that don't put this attorney in this conflict situation, and you can be liable under Section 552 of the restatement. Okay, so that was pretty dense, but it's a very important point. And again, you should review the McCamish case in connection with any Rule 202 evaluation that you're giving, because you need to be cognizant not just of your ethical duties and responsibilities, but of your potential liability to third parties. Because just because you follow the disciplinary rules doesn't mean there's not going to be a cause of action against you. The two things are separate, but they are related. Okay, so moving on to comment 4 to Rule 202. I wanted to just bring this to your attention because it talks about when attorneys are asked to serve as investigators. Sometimes, and in particular, I'm thinking of HR issues or employment law issues, lawyers are asked to go in and conduct an investigation. Was there a violation of the employment laws or this, that, and the other at this company? And they might find themselves interviewing a number of employees of that corporation. And so what comment 4 says is when an attorney is doing something like that, they're serving as an investigator, the identity of the client is critical because only the client has a confidential relationship with a lawyer. So you have to keep in mind in that situation, your client is the corporation. Your client is not these employees. And if they misunderstand your role, then it is up to you. You have a duty to clarify your role with those non-clients. And this kind of duty to clarify any misunderstanding about the lawyer's role is not just present in this rule, it's present in other rules as well. And it's generally also a duty in the case law. So if someone that you're interacting with thinks that you are their lawyer and you are aware of that, you've got to affirmatively dispel any notion that you're acting as their lawyer. Okay, if you are finding yourself in a situation where you are giving third-party legal opinions in a business transaction setting, there are a number of resources for you that you really need to consult. And I have them listed here on the screen. The ABA has a Legal Opinions Resource Center. It has a number of links for a number of different situations where lawyers might be called upon to give these third-party opinions. You need to go here, you need to find the link that is most appropriate for your situation, and you need to read all of that commentary. It will give you guidance on what the lawyer can and cannot say, or should and should not say in those opinions. It also will give you outlines or forms that you can use if you're giving these type of opinions. It's very, very helpful. There is an ABA statement on the role of customary practice in the preparation and understanding of third-party legal opinions. There's ABA legal opinion principles and guidelines on the legal preparation for closing opinions. And then Texas has adopted these ABA guidelines and principles. So all very important resources that you need to consult before you do any kind of third-party legal opinion. Connected to that are audit responses. Lawyers are often contacted by a third-party auditor that is auditing their client, in particular when you're dealing with corporations. And you'll get what's called an audit request letter. And so comment 7 to Rule 202 talks about this situation. And it says, when a question concerning the legal situation of a client arises at the instance of a client's financial auditor and the question is referred to the lawyer, any response by the lawyer should be made in accordance with procedures recognized in the legal profession. This is important because there are standards for audit responses. And the main one, kind of the one that is the Bible, so to speak, the place where you would start, is the ABA Statement of Policy regarding lawyers' responses to auditors' requests for information. And then there's some supplements to that, but that's where you need to go to that place first. Again, it tells you what you can and cannot say, how you should say it, and it gives you examples in the appendices of different forms that can be used. But this statement of policy is what they call it from the ABA, outlines the general framework for lawyers to provide information to auditors about their clients' loss contingencies. Lawyers are generally expected to respond to these kind of requests, but usually cannot do so without the client specifically requesting it. And most of the time, the client is. And so, again, this is a starting place, but you must consult that statement of policy before you respond to any kind of audit letter from an outside third-party auditor. And that is our Fast 15 on Texas Disciplinary Rule Professional Conduct 2.02. If you have additional questions, please feel free to contact me at rskmgmt@tlie.org.